Dear participants, dear friends, first of all, a very warm Happy New Year, in the hope that this year will enable us to have many more global digital encounters. We have planned a series of fantastic encounters for this year, but also many occasions for all of us to meet in presence and to enjoy again the warmth of social life with less COVID worryings. In this very moment, it's really with emotion that we are now launching the 18th Global Digital Encounter. This project, which was launched by the Fide Foundation in Spain and the Transatlantic IP Academy, is a project aimed at really reviewing, reconsidering horizontally issues connected to intellectual property. As co-director with Professor Manuel de Santos of this project, I really warmly thank you for being so numerous today, as per usual practice, to our Global Digital Encounters. And especially, I would also wish to thank our numerous supporters all over the world, the support entities that permit us to develop this pro bono activity, and all those who disseminate the information all over the world. So my special thanks are to academics who are connected today, to professionals who are connected today, to students, to the younger generations who are empowered thanks to the encounters. Today's topic is dedicated to IP and video games. Why? Because video games is one of the fastest growing sector of business sectors currently, with the digitalization of economy, with the digitalization of business. Video game has a much really great importance, and video games is one of the sectors that steadily develop in a fantastic way. However, the area of video game, the business area of video game, fantastically spurred by the pandemic, but already fast developing before, is confronted to a certain number of intellectual property issues, like many dynamic digital sectors. For these sectors, there are specific issues that do not put into question the IP system, whereas the video game area really brings major question marks, including on video games and work of art, video games and copyright, video games and the rights, the IP rights that are connected to them. Video games and consumer rights connected to IP rights as well. Video games and regulation of society, including privacy issues. So altogether, for conducting this Global Digital Encounter, we have an exceptional panel of speakers with us. We have Professor Alina TRAPOVA from Nottingham School of Law. We have Professor Andrea RIZZI, who not only is a private practitioner specialized in video games, but also teaches at Queen Mary School of Law in London. And we have as moderator Professor Carmelo Fontana, who is legal counsel at Google and is also professor at Bocconi University, contract professor at Bocconi University, involved in teaching on contracts and technology. So it is for us a very special honor to have this exceptional panel. A panel that has a vision, 360 degrees vision over not only the European experience on IP games and IP, but also a worldwide experience. At this very stage, I would wish to leave the floor to our panel so that we really go ahead and make you empowered with the topic of IP and video games. Our coordinator, Professor Javier Fernandez Tasquetti, would wish to say a few welcome words before we leave the floor to our panel. Javier, the floor is yours, and welcome to our team.
Thank you very much, Laurent. and it's a very big pleasure for me to be here once again and welcome you all to this encounter. I hope you hear me.
Yes.
Do you hear me? Yes.
Yes,
Wonderful.
we can hear you.
So, just a few words. You know, the video game sector is not a game, but it's an economy sector. Let me give you some figures from the Spanish market. Some 650 developers, some 1,700 million euros of sales in 1 year and growing. Okay, so it's a vibrant sector. In French, we would say pétillante. Okay, like champagne, and it's growing and growing. So it will grow in the future. Recent takeovers, such as one of Microsoft, very recent, and others, that will drive us to a higher growth of the sector and probably to new situations because of new technologies such as or not so new technologies such as the metaverse, NFTs, and so on and so forth. So. Thank you for being with us. Remember that we belong to a community, so we expect to have your comments and thoughts, and that's all I wanted to say. So the floor is yours, Carmelo, to drive the encounter. Thank you very much.
Thank you, and thank you for having me. I'm very excited about this meeting. I'm very excited about the guest speaker that I will be moderating. It's very interesting, and I think I will be learning a lot myself about the issues with the IP, intellectual property, and video games. But I think even for those who are not specifically dealing with the intellectual property and video games, this conversation today is going to be very relevant. Personally, I think that whenever you're analyzing trends, dynamics, industry issue in an industry that is exploding like the one we're dealing with today, you can gather some general dynamics, a general sense on how the legal system is reacting to challenges. And the challenges with video games are not just legal, are social, cultural. They're intertwined with the very concept of creativity, with the evolution of communication. There's a word that I'm sure you've heard lately, is gamification, which is to describe a way of engaging communities, communicating with the broader audience, and leveraging the interactive abilities of the media nowadays. Just to give you also some figures concerning the explosion of this industry. We talk about the money, but I did a little bit of research myself. The turnover with the video game industry for 2021 was 178 billion. And if you look at what has been the growth, was at 23 billion. So just the expansion of the industry in itself, 23 billion, will be bigger than many other industries that we're familiar with. And by the way, the movie industry, the music industry, the content industry in itself doesn't even compare to what the video game industry has been doing in the last few years. Another piece of trivia that I think is interesting, the projection of the growth for the next 5 years is even more amazing, is 250 billion by 2025. And traditionally, these estimates have been surpassed by reality, so we don't really know what's going to happen. So starting with these figures in mind, I will not take more time from the speakers. I wanted to ask Alina and Andrea, how do they see these trends, and how this explosion of the industry has changed what a video game is nowadays?
Shall I take it, Alina? Okay, I'll take it. Thank you. Thank you. Hi everyone. I mean, it's interesting, perhaps to flash out the kind of evolution quickly of games as products and services from coin-operated machine used and very popular during the 70s. A video game would be regarded initially as a product, meaning there's a physical, tangible medium, a DVD, a disc normally, embedding software and the other content. And the consumer back in the day would just pay a one-off sum to be able to buy the game, and the game would play endlessly, potentially, for the benefit of the purchaser, of the consumer. And that is that period where games were, essentially a disk embedding software and other information and content. That moment evolved with the advent of the internet and the explosion of digital distribution. The products evolved into something else, and we refer that as the concept of game as a service, meaning the consumer is no longer limited to the content that they bought initially, because the publisher, owning the rights to the game, starts adding content subsequently to the sale, downloadable content, effectively adds on additional content purchasable through microtransactions, meaning small amount transactions that enable the consumer to access additional content above and beyond the content that was initially available upon purchase of the normally the main game. The games evolve towards a service type of proposition through the use of new business models, subscription, for instance, based models, and all these new business models are effectively designed to extend the commercial life cycle of a game. During the year 2000, I think we have witnessed a trend in the video game industry very similar to what happens with Hollywood type of film industry, meaning most of the success and therefore the money would concentrate on few big hit franchise titles, very expensive to produce but commercially successful, and this is what we are seeing now, actually, of the money generated by the industry. The top title, the most played, the most successful, the most popular titles make a significant portion of that.
Jump in as well here, talking about the revenues and the way that video games actually sit together with other creative industries. I think it's also very important to highlight that, different to music and film, video games actually are the industry where we see lowest levels of online piracy. I mean, now we are seeing this a lot more, different business models in the film and the music industry, but video games being something born digitally, living their life digitally, and evolving and being constantly updated. As such, there was a report several years ago from the Institute of Information Law at the University of Amsterdam, which studied the global online piracy trends, and it highlighted very, very clearly that video games, because exactly they have pushed to live in this model as video game as a service, consumers pay for them. They don't pirate. They pirate a lot less because they want to have the real deal, and it's much more difficult to actually live in this piracy environment as a video game. And this makes me think a lot about the legal status, the legal nature of video games. So tying this very concretely to the copyright and the IP issues that we have at stake, we have this evergreen question that we thought at one point was set to sleep, but it turns out in the last years that it's not really set to sleep. And this is the question of what kind of a work are video games from a copyright law perspective. So are they a software? Are they an audiovisual work? Are they a combination of these? We had the Court of Justice in the Nintendo case telling us clearly that video games are a complex subject matter, and therefore, they don't entail just a software. They entail also audiovisual elements to it, music, and things that are very different to just the pure software. And this is, I think, it's very clear when we look at modern video games. So take Cyberpunk, take all these huge projects that start their life years and years ago, and they come together with film stars, premieres, suspension, musical scores, stars that appear there. So I think the notion of a video game has definitely moved into the service box, but the law seems to struggle with it because we have, especially from a copyright perspective, we have this friction between the software directive and the InfoSoc directive that treats these elements differently. So I think we're still there.
Can I jump in and say so?
Sure.
So and now just to close the loop on this, and now from apparently we are entering the product the game as a platform era. And by game as a platform, we refer to the fact that a game now includes social media functionalities as one key element of the platform environment, which takes games to the next level potentially. And I think this concept is now it is the concept of games as a platform that perhaps is evolving in this new multiverse kind of concept, meaning permanent, fully connected through the use of immersive technologies such as augmented reality, virtual reality, and create ecosystems that apparently, are rooted in certain kind of literature. Ready Player One is a good movie, I think, to try and grasp the concept of the multiverse. So and this, of course, changes has implications not only from an IP perspective, but also from a regulatory perspective, as platform operators or publishers managing a video game environment such as, I don't know, Fortnite, you might be familiar with, because of the key role played by interactivity of the community and because of the interactivity and the amount of user-generated content, this puts the platform in a potentially more difficult situation in terms of potential liability vis-a-vis the context and activity that happens within the game environment, within the game platform. And
that is
I'm curious if, I don't know if Carmelo wants to.
No, I was as you were mentioning this dynamic, I was thinking that going back to my point, how the evolution of an industry can be telling of the ability of the legal system to react and recapture all of these phenomena. It is amazing because now we're creating within the video games the same dynamics that distribution platforms have had with video games and other applications in the past. And so to add what Alina was saying before, we had to deal with the copyright directive, InfoSoc directive, and now all of a sudden video games themselves will be engaging in enforcing e-commerce directive and platform liability immunity. On top, you're going to have a platform to business regulation because all the developers and the distributor of content that are professionally operating on top of a video game platform would be subject to this additional layer of regulation. And then on top, you would have unfair commercial practices, misleading advertising, and all of these other pieces of rules that would traditionally apply to online platforms and would target video games as a channel to distribute additional content on top of the platform. So you will have this potpourri of different rules that are in a way designed to tackle separate issues, aligning with the traditional creativity of video games, where you would have the artistic creativity within the interactive platform, but then you're going to also have the marketing creativity about how to sell these services and third-party services within the platform itself. The scenario is very complex. I wouldn't want to distract from the main topic of the day. So maybe we can go back to copyright, intellectual property, and maybe Alina wanted to comment on the distribution, communication to the public issues and more traditional copyright challenges and how the video game industry is shaking the foundation of how copyright law operates.
Thank you, Carmelo. Yeah, but in fact, what you're saying on the regulatory framework, I couldn't agree more, because now with the Digital Services Act in the making currently, what we had from the e-commerce directive before, and coming back to copyright, the copyright directive from 2019, which we still don't know how it's actually going to work in practice.
I will interrupt you. No.
Oh, am I having a connection issue?
Nope, it's on Carmelo's side.
Yeah. I was interrupting you. If you could hear me.
Yes, I can hear you now.
Yeah, I was saying that all of this is still specific to Europe. Then you would have to consider how all these rules would again connect and regulate businesses operating globally. So on one hand, you would still have copyright directive and the e-commerce directive. On the other hand, just to mention the US regulation, you would have to think about Digital Millennium Copyright Act and Section 231, and so it's even richer, the scenario.
No, absolutely, yeah, absolutely, and that's exactly just a little part of the big puzzle. But what we generally see, just to close a little bit on platforms, is platforms are starting to be made more responsible for what they host. That is, they're gatekeepers. So the legislature, whatever it is, primarily the European legislator, seems to push for more liability for platforms. Now, whether this is only in IP context, that's very clear. But what could happen and what the risk globally is that what we do here in Europe, if we get it right, that will certainly be replicated in other places in the world, around the world. If we get it wrong, and if it gets replicated wrongly, then that risks creating a lot of damage for different sectors. And going back to video games more specifically, we know that they are a very complex subject matter. And these distribution and communication issues that arise, they are in terms of copyright law issues, these are very classical topics that we have tackled for many years. So to put it in the context of video games, modern video games, so we would have, again, a platform such as Steam and the like, and you would be, as a user of it, you would be, I wouldn't want to say buying, but I would say getting your access to games from through the platform. And then the crucial issue is what kind of an act is this? Is this considered to be an act of distribution, or is this considered to be a sale of the games, or is this going to be a communication to the public? And then we start seeing this divide very clearly between a sale and a license, between a good and a service, so if you want to call it a product and a service. This is relevant for copyright, for IP issues, because the right of distribution is exhausted, as I'm sure many of the people that are listening today will know, while the right of communication to the public is not. And on top of this, there's the additional difficulty of actually placing the video game within one of the two directives that we have in Europe. So that will be either the InfoSoc directive for general subject matter, or the software directive that is, as we said already, following the Court of Justice's decision, that is actually lex specialis. So we know so we had several years ago, I don't want to become too theoretical, but you forgive me for that because I work at the university. So if you need to interrupt me, just interrupt me whenever you need to interrupt me. We had a case from the Court of Justice on ebooks. So we had Tom Cabinet several years ago, which tackled a subject matter, ebooks, that I don't want to say is exactly like video games, but comes closest to video games from all the subject matter that the Court of Justice has actually tackled so far. We don't have a case on video games tackling exactly distribution and communication. We had Nintendo figuring out what video games are. And there the Court of Justice says something very interesting, that it actually says that when trying to figure out what kind of a work we have before us, we need to look at the whole thing, and we need to also actually, though, bear in mind the elements that make it up. So for ebooks, the court says that the software of the ebook is only incidental in relationship to the whole book, because you get an ebook to read it. So drawing on this for video games, we start thinking, oh, okay, well, do we get a video game, a modern video game, because its software is fantastic and it runs amazingly, with all the newest technology attached to it, or there's much more to it? And we already said video game is much more to it, but I don't want to be too one-sided on this. And despite my personal views on that, I want to actually, admit that software plays a very big role in video games, in modern video games. There's a lot of development there. On the basis of this, Germany and France have had several very interesting decisions dissecting video games. So those of you that are very interested in that, I'll look into what the German and the French courts have said. As I said, I don't want to become too theoretical, but I want to see what you think on that. Do we actually, do you, Andrea, from your practice, do you reckon that we actually buy games on Steam, or do we subscribe to them?
We subscribe to them, I think. That's my that's my take. Definitely a subscription.
Well, I have to say that trying to draw some comparison with the music industry, even when you're buying a song, you're not really buying it anymore. you're just getting an electronic sell-through of a content that is based on a license, and therefore it is. I think we're culturally, as the service industry is the consumption of every kind of content and service is becoming more common, more accepted. I think we're progressively going in accepting that everything is going to be a subscription, as long as you're going to need the support of a platform to enjoy the service in itself. If you, I don't know if you agree with that.
No, I think that's very much where we're headed to, and looking at the modern games, the big ones that we have that are on the market nowadays. Trying to put them within the sale or the license box, or within the goods or the services. Actually, underlying all of this, there's a paper that I co-authored on this, and what we dug there with my co-author were two dichotomies. So we looked at modern video games, and we actually unpacked them from the perspective of the sale license dichotomy and from the perspective of goods services dichotomy. When we looked into sale license, it was very important to figure out that this is actually the relationship between us as game purchasers and the platform. So are we buying or are we subscribing to? And it was very important to draw the line between this kind of dichotomy and the goods and services dichotomy. They overlap, but they're kind of slightly different. Because when you talk about goods and services, you are on one end a user, you put one against each other, the game user and the game company. So as a game user, actually, as a player of it, you get access to all these services. I completely agree with you. We came to the same conclusion. But just to anticipate a little bit, this is not what the latest decision in Europe has said. There's a case on appeal from the Paris court. It's a French case, it's a national case, tackling exactly that same question of Steam and whether actually the Steam accounts of the players are subject to exhaustion or not subject to exhaustion, whether they are, this could be considered communication or distribution. And the Paris court actually didn't go down our way. And you can imagine that Valve was, and the video game industry broadly speaking, was very upset with that decision. So all of these cases that we see, is very interesting to put this in a bigger context, that they come from the perspective also of consumer rights or consumer law. It's not an IP vacuum thing. All these cases have been brought by consumer rights associations, and on this, I think I tend to agree that consumer law does have something to say about all of these expansive end user license agreements, but I would not mingle too much with exhaustion and distribution. I think I spoke too much.
No. If I may, because I mean, in practical terms, because it affects the possibility of a second market for games developing effectively, which is something that right holders in the video game industry have always tried to prevent, actually. Maybe a bit of greed on their part. So this has been, whether it is legitimate to have a second-hand markets for games, which now in the digital environment means in order for it to be, there cannot just be a disc being passed on from one person to the other, but because of this new dimension of games as services or platforms, indeed the transfer of ownership to the game and it comes with the package, and complexity and some complexity. Sorry.
No, thank you. So it's been written in the chat too. If any of the participants would like to ask questions, they could do so either by writing, typing in the chat box, or you can also speak and address directly the rest of the panel. So don't be shy. We would like to have a conversation here. Moving to a slightly different topic, we've been discussing how the relationship with the users, the consumer, has shaped some of the assumption that would also have implications for intellectual property. And I would like to ask this to Andrea, but what are the criticalities, the sensitive issues concerning the relationship with the third parties, creators, and competitors, and what are we observing on the industry? How these IP claims or copyright conflicts are playing out in the video game industry?
Okay. Well, obviously, we've said that the sophistication of video game products and services has increased significantly because technology now allows that. This means that now, as works of expressive works of art, games have reached a status which is not widely or necessarily recognized by everybody, but the perception of games as of video games as a medium, as an expressive medium with a dignity is becoming more and more common, luckily, I would say, and therefore this allows for the reproduction of existing of real life people, vehicles, items as a narrative tool in the context of applying realism as a narrative tool to video games. This creates a tension potentially between the expressive right, the right to free speech, or freedom of expression of the developer to be able to freely use material which is protected by third-party IP rights, be these rights, under copyright law or trademark law or image rights, which I will maybe say a couple of things specifically on, creates the tension between the right to freedom of expression of the developer and the right of the right holders or of the person to control their own image. And this is a very fascinating area, I think, intellectually, but also very of practical relevance. And why is that? Because in order for the game to be lawfully distributed and recoup on the investment, obviously the product has to be legal, and to be legal, it has to not only comply with all applicable laws, but also avoid infringing existing third-party rights. And it's very and if the content was not legal, then of course, because for instance, it violates a third-party IP rights, then we all know that the potential consequence for that is that the publisher might not be able to commercially exploit the game because normally as a sanction for the violation of third-party intellectual property rights, the right holder can apply for an injunction and have the distribution of the game enjoined, which means the publisher will not recoup on the investment. So dealing with IP, clearing content in order to avoid violating third-party rights and potentially being impacted by this in respect of the possibility to distribute the game is a very delicate operations, and the biggest publishers they have big in-house team vetting and reviewing content to ensure the legality in fact of the content. Now, and there's a lot of work for lawyers in this space, and it's challenging work. And why is that? Well, because of, on the one hand, the territorial nature of intellectual property rights, on the other, the need for widespread, essentially global distribution of games, which, given the costs that they involve in order to be produced, they need a big market, a global market. So lack of harmonization on the one hand at international level, with lack of treaty in the field, for instance, specifically to image rights. There's no harmonization. There's no harmonization at international level at all in that area. And copyright also, arguably, you know, it's harmonized only to a certain extent. Perhaps trademark law is more harmonized, but anyhow. So territorial nature, need for global distribution to recoup the investments, and lack of harmonization makes it challenging for lawyers reviewing content to make judgments when, particularly, the developer, which is something that of course does happen, knock on the lawyer's door and say, well, I don't want to have to take a license in order to be able to include this, for instance, a famous person or celebrity in my game, because the inclusion is needed for me to be able to, for instance, recreate an historical setting, and therefore the inclusion of that person enables me to achieve the creative result effort that I am planning to have. So very difficult sometimes, and of course this applies, and I want to emphasize, when we are thinking about realistic games in particular, where the inclusion of third-party rights protected material becomes a narrative tool, and therefore where do we draw the line between the freedom of expression rights of the developer not to have to ask for a license, and the right of the person, the celebrity, for instance, to control their image. Whether, I mean, in addition to, if I do decide to take on a license, then of course there will be costs involved. But it's not just a matter of costs. While on the one hand I might be able to, well, I should be able, by taking on a license, to benefit from the services and the support of the licensor in promoting, for instance, my game. On the other hand, I will, as the developer, lose probably creative control over my creation, because the licensor will want to have their say normally, which compresses the right. Yeah.
Andrea, thank you very much for this explanation. We have a few questions from the participants, and there are some interesting ones that I wouldn't want to miss out. Just my personal remark on how this dynamic regarding clearance of third-party rights and image rights is sort of creating some resemblance with the movie industry, which is, you know, for the creation of regional content, platforms like Netflix, Amazon, even YouTube. We have a lot of work relating to clearing the rights and acquiring editorial responsibility for all these uses of content. So it's an interesting way it's unfolding. So the questions from the audience. One is regarding cloud gaming. It's a specific question about the acquisition of Activision by Microsoft. I would like to make it a little more general. Do you think cloud gaming is sustainable long term and respectable of IP rights? I would say, what are the specific legal implications of cloud gaming and how this could be critical for the industry? And I don't know, maybe Alina, you can take this one.
I can start, but I'll definitely pass the ball to Andrea. So very briefly on the Microsoft Activision news. So bear in mind this is still under scrutiny by the US antitrust authorities. Whether this is going to be a reality or not, it will really depend on antitrust laws. Now this brings in a slightly different dimension to our video games and IP discussion. As for cloud gaming, this is becoming more and more of a thing. Andrea I hope will tell us from a practical perspective, how much are clients engaging actually into this, because he has a direct overview on that. But I think this will bring in also very same old topics that from an IP copyright perspective we have been discussing: distribution, communication. Where do we stand? And I don't exclude the possibility of, cases coming around and litigation arising, bringing up the same, old wine in new bottles, as like you would say. So I pass the ball to Andrea to tell us a little bit on cloud gaming from a practical perspective.
Well, I don't have, to be honest, much in the sense that it is the future, is the technology and the infrastructure ready to support it. I think that's the key. I think that's the key question, and things are evolving. I mean, that's what I expect. It's, I think, primarily a matter of technological enablement. I think we're heading in that direction. I think it's a trend that will continue necessarily, and it's the same for mobile gaming. It's clearly the future. The number of smartphones around the world is unbelievable, and that enables or has enabled a massive increase in actually the number of gamers, and that's the other, I think, side of the future in a way of video games and video gaming.
Thank you, Andrea. Another question from Serena. In some video games, the user can become a creator, for example, in Minecraft, which my son is very fond of. Yep. Can user creation be protected as an IP, and how do we deal with terms and conditions of the video game platform? So this is actually very interesting. And I think the complexity is also whether or not we can regulate by contract between the provider of the game and the user copyright, and what will be the outcome of that.
It's just go on.
I can take off and then pass it on to you. The user's creations protectable with IP, and how does that stand in opposition to the rights that the game company will have? So who would have copyright? I would suggest that that's the relevant IP right. Who will have copyright in this output? Would it be the user of Minecraft that plays the game, or would it be the game company? Now, this is popping up in very different formats, this question, especially through the application of also artificial intelligence and machine learning systems in this very complex technological environment. From my research, there's one country, not one country, several countries have a provision in copyright law that grants protection for computer-generated works. And there's been one case coming very close to this type of scenario in the UK. It's a rather old case. It doesn't tackle actually a sophisticated, modern, and game as a service type of game that we are talking about today. It was pool type of game. So it would really depend on how much the user actually has that freedom to express their free and creative choices by playing the game. So by building stuff on Minecraft and expressing you as a player, your own intellectual creativity, your free and creative choices by playing the game, that would be the crucial element. It is very difficult from how games are from their pure nature. It's very difficult to reach the conclusion that the user will automatically and always have a copyright claim of whatever they create in these games. This is due to the fact that a game comes through the design of someone else, and that would be the right holder in this specific case. So you, as a user, you operate within certain creative constraints. So even in a super creative game, such as Minecraft, where you can express yourself so much, you still are within the limits of the creative restraints that were built into that game. You can't go beyond that. And this is the so-called technical constraints that limit your creativity. So you may not actually be able to express yourself enough. Maybe I leave the second part to you, Andrea, for the terms and conditions.
I was thinking, what is interesting, perhaps, I think, is I remember when I started working as an in-house lawyer in the industry, actually for Activision Blizzard, which today news, I think, it's been acquired by Microsoft. I remember, and that was back in, I think, 2008. Those years, from 2008 onwards, there was almost an obsession for publishers and developers to actually own any user-generated content, and I guess that was driven by fear that they might get a claim at some point along the line because they didn't own the rights to user-generated content being used by the publisher. I think now we are seeing a more relaxed and probably better approach, whereby often the ownership of user-generated content is left with the user of the game and is not acquired. And I think this is because it is perceived that it's a fairer way of engaging with a member of the community who may add value, particularly in this context of these immanent persisting worlds, which needs constant updating and novelty. Yes, I think there's a shift. There's a shift, probably a shift in the way users and contributors are perceived in this new.
Which Andrea, by the way, I'm a little biased on the topic, which I think is also consistent with what social media and video sharing platform has established as general policy, that you don't really want to engage disputing the ownership of any IP. You just want to get a license that is technically sufficient to operate your activities, and as long as you have that, you don't have to care whether or not the user is going to be able to to re-access, redistribute, and make this content portable on other platforms. In fact, I think the whole concept of portability has been a winning one, both for data privacy profiles. There are a lot of questions, and I think we have the ability to follow up later on separately with some of these questions. But I think there is another one I find interesting. Is the last one on the chat. It is about the Activision Blizzard acquisition you were just mentioning before, Andrea. And the question is whether or not after Microsoft, who is the owner of Xbox, has acquired Activision Blizzard and therefore the IP rights for games like Call of Duty, will be is it possible we'll be having compatibility issues with the use of these games on other platforms like PlayStation? So again, we see how this relates to other areas of the law and whether or not this kind of dynamic could create competition law issues. And so portability, compatibility, and platform dynamics are at play also with video games. What do you guys think?
I'll say this. Alina obviously mentioned that now the merger will have to be cleared from an antitrust perspective in the US and in the EU as well. Now, this there is still no market definition applicable to the video game industry, and I think so the last case where the Commission, the EU Commission, dealt with market definition, it was actually the merger business combination between the then Vivendi Games, a batch of companies, and Activision, which created Activision Blizzard back at the beginning of year 2000. Now, it was a big merger, and the fact that the Commission did not really even attempt a definition of what the relevant market would be in order to assess whether the merger should go ahead or not, I think it says a lot in terms of the lack of the lack of sophistication or attention on the part of authorities, which is traditionally a characteristic of the video game industry. If you compare the level of maturity of reasoning, in terms of antitrust law that you would apply to traditional entertainment industries, right, and which has never been applied to the video game industry, I anticipate that this will be an area fastly evolving antitrust law and video game, because it does pose issues, that you correctly mentioned, and in very simple terms means, will I have a PlayStation? Will I be able to buy Call of Duty at the same time as my friend who has a Microsoft PlayStation, has an Xbox? Yes, and we shall see. Sorry, I've been digressing, but and particularly in relation to esports, where a title is administered, one title. So there's an environment built around one title over which the exclusive rights belong to just one publisher. There is no regulation, right, in terms of, this is the situation generally across the board, in terms of rules specifically developed for the administration of league tournaments, competitions, right? This type of stuff. I think antitrust will have to deal with the issue of the publisher having total control over its own gaming environment in relation to the title that the rights of which they own. So this.
Thank you. Another topic that is interesting to me is the use of NFTs, so non-fungible tokens, as a way to control IP circulation in games. Is definitely something that it's already happening, and it's an interesting stress test for IP theory. What's your take on the use of NFT with video games? It's gonna stick? Is it something that is a fad that is gonna go away, and how is changing our reasoning?
I think this is already now we should wait and see the impact of it, but it's already pushing for a lot of changes, and companies are getting into it. So, but what's important to keep in mind with NFTs is that, yes, it's true that NFTs constitute this sort of a certificate of ownership, right, of this digital asset, this digital good. And it has the benefit of being there for a limited, very limited quantity and an exclusive quantity. So yeah, Fortnite skins being offered as NFTs, and players that first unlock them and first get to them in game can take ownership of that. But this ownership that we're talking about here, thinking about intellectual property rights, it should not be confused with ownership of the intellectual property rights. That's why games become very, very complex subject matter, and we can't box them into being just software or just creative and audiovisual works. So I think in the long run, we'll see what happens with NFTs, but as always, we have to be very straight on the basics from the beginning. The fact that you own an NFT does not necessarily mean that you have anything to do with IP there.
In fact, you probably don't at this point in time.
So very well, we are getting a little bit over time. I think we should leave a little time for some closing remarks. I think Professor Manuel de Santos Real wanted to add something before the end of our conversation. I wanted to thank all the participants and definitely the speakers for entertaining us with this very enlightening conversation. I personally learned a lot. I'm very happy to have had the chance to participate. So thank you everybody, and now give it to Professor.
Thanks.
Thanks very much, dear Carmelo. We do appreciate very much your skills as moderator, yeah. But I would say that we do appreciate it much more today, because you have dealt with a very demanding and horizontal topic. And on top of that, your connectivity was not optimal this time, let's say. So as Janine Rizzo has just written in the chat, she says, this conversation only confirms that video games have always challenged the limits of IP and will continue to do so. So I cannot agree more. So there, Alina, and there, Andrea, we are very grateful to you both. We could have spent 1 hour more moving from one issue to another, and we would have been very happy listening to you. But what you have told us, you three, show that the exponential growth of this sector is just amazing. When listening you, I realize how many things are going to change dramatically in the IP world in the following years. So thanks very much to you three for having accepted to think with us today, for becoming part of our Encounters family. By the way, I would like also to mention especially all the students from Bocconi University, Internet and the Law Master, the students also from the University of Alicante Digital Society Law Masters, and from all the students from many other masters all over the world. All of them are massively following the Encounters month after month. Yeah. I don't want to miss also thanking Etu Uta from Finland, and Adele Serio from France and from Italy. They are members of the Encounter Support Group and will be the responsible for drafting this report. So you will have the report next week available already. Many thanks also to all those who have sent questions to the panel. We had dozens of questions. We could not deal with all of them, but for sure they will be answered by the panelists in written, and we will publish these answers. Yeah. So now it is time to close this 18th encounter by recalling you that we will have our next encounter, which is that is already the 19th, on February 23rd, 2002. For the first time, we will deal with audiovisual and artificial intelligence, a topic that is certainly, I believe, at the very, very heart of the future of intellectual property. So please take note, February 23rd, 2022. We will advertise the exact hour and the name of our speakers in the following days. So thanks very much to our speakers, to our moderators, to Fide, to Tipsa, but most especially also to Álvaro Arribas, who is our technical master coordinator. Without you, Álvaro, this would not be possible. And also thanks very much to all of you for being here today. You know, we are very grateful to all of you. We appreciate whatever advice, whatever criticism, whatever suggestion you could provide to us, and we will try to improve more and more the encounters day after day. We do believe now we have quite an amount of staff online, and this is a very valuable legacy for the future, and it is a common legacy to all of you. So take care, come again, please stay with us February 23rd. Do count on all of you on our next encounter. Thanks for being here with us. Enjoy the rest of the day, and bye-bye.
Thank you.
Bye-bye to all of you. Thank you.
Bye-bye.
Bye-bye.
Thank you.
Thank you. Good morning, good evening, and good night for those who are in Asia.